Hello and welcome to the first installment in Pacific Legal Foundation's Battleground America event series, examining critical issues at stake in America. My name is Daniel Du. I'm the Legal Policy Director at Pacific Legal Foundation. In today's discussion, A Delicate Balance, Liberty and Security in National Crisis, we'll be exploring how we can balance the government's need to act in times of emergency with constitutional safeguards. We have a great panel. Mark Miller serves as general counsel to South Dakota Governor Kristi Noem and as a member of the governor's executive team. Ilya Shapiro is the director of the Robert A. Levy Center for Constitutional Studies at the Cato Institute and publisher of the Cato Supreme Court Review. And I'll also note that he's the author of a recent and timely book, Supreme Disorder, Judicial Nominations and the Politics of America's Highest Court. Luke Wake is an attorney at PLF and our Separation of Powers practice group and does great work there. We'll be leaving time at the end of the conversation to take questions. So please submit them at any time using the Q&A feature in your Zoom window. But I want to go ahead and give us a little bit of a preface to this discussion. Since the beginning of COVID-19 almost a year ago, governors and mayors have been governing unilaterally. They've been under the guise of emergency powers. State legislatures and courts have delayed too long in stepping up and fulfilling their constitutional roles. Whether you believe that the government has done too much in response to COVID-19 or not enough, what happened over the past year sets a terrible precedent that individual governors or mayors can wield unfettered power indefinitely simply by declaring an emergency. So as a result of this, the framework of government has been trampled over the last year. The Bill of Rights gets a lot of credit for protecting individual rights, but as Justice Scalia used to note regularly, every banana republic has a Bill of Rights, but those Bill of Rights are not worth the paper that they're written on unless they're enforced through a solid structure of government. So this is the way we've been operating since March. Unfortunately, we've been fighting this on a number of ways through litigation and also through our legal policy team working with state legislators to ensure that they have the ability to step up and fulfill their constitutional duties to make law. And so with that, we're going to get right into it, and I'm going to start asking some of our great panelists questions. And the first one I'm going to start with is, what powers and authorities do governors inherently have to deal with emergencies? And on top of that, what additional authority have state legislatures granted to them? And Mark, do you want to start off since you're in a governor's office now?
Yes, sir. Thank you, Daniel. And thank you very much, Pacific Legal Foundation, for inviting me to participate in this webinar. I think that particularly if we're talking about national crises of the sort of pandemic variety that we're dealing with now, the Supreme Court recognized way back, Chief Justice Marshall, and I'd written a piece on this a year ago, or not quite a year ago, when the pandemic began. That, the government does have quite a bit of power through the 10th Amendment, the state governments, to respond to a crisis like the pandemic we're dealing with today. In Gibbons versus Ogden, which was not a pandemic-related opinion necessarily, but Chief Justice Marshall referred to the fact that it was well understood that a state government could, say, quarantine people or shut down the roads in response to a health crisis like we're dealing with now, a crisis that might be contagious. In fact, the crisis then they didn't know was not contagious, but it was reasonable to think that it could be responded to that way. And in fact, the Supreme Court of the United States was shut down a few times at the beginning of our country's history because of dealing with pandemics. So really, any power the state has is ultimately going to be the powers we, the people, have delegated to it, whether it be the federal government or the state government. And but some of the powers that the government, state governments have been trying to take on for themselves over the last 9 months or so do seem to be well beyond at least what we think in South Dakota is proper. And really, I think the business shutdown orders seems to be just a bridge too far. If you look at our nation's history, and it was Larry Salzman at Pacific Legal who, at least for me, was the first person I saw identified it, that generally this concept of business shutdowns on the mass level that we saw, this distinction between essential business and non-essential business, was just unheard of in our nation's history. It was a power that governors just seemed to sort of create out of whole cloth. And perhaps what's remarkable is that so many judges and legislatures, judges when these shutdown orders have been challenged often, and legislatures who refuse to then sort of meet in an emergency session, they refuse to sort of second guess the governors. And at the beginning of it, perhaps you could understand the governors were responding to what we were being told was going to result, if the number I recall was 2.2 million dead in just the space of a few months, is what we were first told, which is in no means intended to minimize the tragic loss we've seen. But it was, at the beginning of this, it was much worse than we thought it was going to be. Yet governors went way beyond what I think we thought state governors had ever had claimed before as their power. Beyond the norms. I think a good way to put it is state governors went way beyond the norms of what we had understood to be limited government's role.
Ilya, you've written about this and written about, you know, I think you mentioned that you'd written back in May about, you know, it was time for the shutdowns to end. Can you discuss a little bit about your understanding of what the governor's authorities are in these situations?
So we're talking here about the states, which is an important distinction. You know, the federal government has enumerated powers under the Constitution, and even in an emergency, even in a national crisis, there are limitations. You know, the federal government, whether the president or other authorities, could have you know, posted National Guard troops around New York City to make sure their people wouldn't get out or something like that, or close down ports or airports. Didn't do that, didn't have to. People stopped flying by themselves. Defense Production Act to rewrite government contracts to prioritize production of ventilators or masks or whatever. But at the state level, states do have unenumerated powers, what's called the police power, to regulate for the general health and safety and welfare and morals of society. And a pandemic is the quintessential occurrence where that police power goes into effect, going back to ancient times. And so especially, you know, in the early days, you couldn't get a legislature together to debate and figure out what to do. It's quite proper for executive officials to act. But after a while, as Mark was saying, there is time for the legislature to act. And different states do have different rules about emergency powers sunsetting, or the legislature having to re-ratify them, which has happened. In some places it hasn't, and in some places there were violations of either state administrative law, state constitutional law. I think in Wisconsin, their Supreme Court struck down the public health authorities' orders in certain cases as violating state law, and that's perfectly well. The thing is, as the longer a pandemic gets, the more the response has to be tailored because we learn more information. We know what works, what doesn't. And so the leeway that courts give during an emergency, once it's no longer an emergency, I mean, we're into month 10. And once you have something that's long lasting, it can still be a very severe, serious situation, but it's no longer an emergency. And so legislatures need to go back in and, you know, either create new powers or legislate new things in different ways. And courts should begin to be, as they have been gradually, more skeptical so that restrictions on various kinds of liberty, whether it be religious or economic or Second Amendment or what have you, actually are tailored to those compelling government interests to prevent the spread of contagion.
Yes, I thank you for that. And Luke, I'm going to pull you in here, and going off of what Mark and Ilya have already talked about, and especially Ilya's description of the police power that reminds me of going through some of the powers that are granted to governors in times of emergency, and a few of them actually just say that the police power of the state is given to the governor. Are there any constitutional, talking about state constitutions, are there any safeguards to the legislature just punting its authority to the governor for an unspecified amount of time?
Well, yes, there's constitutional doctrines that are very important, and we at Pacific Legal Foundation are pressing those doctrines in various court cases right now. One challenging Roy Cooper's authority in North Carolina to continue with business closure orders, also challenging Governor Newsom's authority to continue shutting down businesses here with this very complex blueprint regime for this color code system restricting businesses based on assessed risk levels. So, but they're doing this on an ongoing, continuous basis. And the radical thing, especially in California, is that the legislature has delegated, literally in the statute says, quote, all police powers of the state. That means that the governor has been given a power that is literally coextensive with the legislature's power. Now, as Ilya just noted, you do have to look within any of these states at the state constitutional, as a starting point. I mean, ultimately, all of this is grounded there. And most states have a separation of powers doctrine entailed there. Some of them are very express in saying that if you've been giving executive power, i.e. you're the governor, you cannot exercise lawmaking power because that is expressly limited to the legislative branch. Others, the state constitution leaves that a little bit more implicit. By only enumerating the legislative power to the legislature and executive powers to the executive. Very few states give any sort of general power to the governor to exercise any free floating authority. And to the extent they do, it's limited. Something like moving the state capital in a time of emergency if there's been some sort of a catastrophe. So the lawmaking power is rooted in the legislative branch, which represents the people on the whole. And appropriately so. The governors are enabled to act because the legislatures have rightly anticipated that there's going to be emergency situations where they cannot quickly respond. And so they want to set up state policy that enables some degree of flexibility for the executive to respond to an emergency. But they cannot, under separation of powers doctrines, just say, we're going to give a blank check to the governor to do whatever he wants. That violates a doctrine. Most states recognize a doctrine called the non-delegation doctrine, which basically it continues with this premise that, again, it's the legislature alone gets to make the law, and they cannot give away that lawmaking power. Most the states are all over the map in terms of how exactly they apply this concept. Some of them have very much weakened their non-delegation doctrine in the view that in the modern age, we need to enable the executive to have some degree of latitude. We ought to allow some broad delegations. But there is I would say, a marked distinction between saying we're going to allow an executive agency, for example, to have some degree of gap filling authority where the legislature has decided sort of fundamental policy. And what we see with a lot of these emergency statutes, for example, in Washington state, Governor Inslee has authority basically under the statute there to do whatever he thinks is appropriate. And much like Governor Newsom, much like Roy Cooper in North Carolina. And I would say that does violate the non-delegation doctrine. Now, a lot of states abide by sort of a general intelligible principle doctrine that's borrowed from the federal jurisprudence. That's traditionally pretty weak. Since the New Deal, the Supreme Court hasn't really struck down anything on those grounds. But some states have applied a more robust application of this doctrine. For example, the Michigan Supreme Court recently struck down emergency authorization to the governor there, which was, she was controversially continuing to shut down businesses. And they said, I think very appropriately so, that when the scope of the power in question becomes greater, so as opposed to a situation where the governor has been given or the executive agency is a very minor, regulatory subject, where we're talking about their ability to regulate literally every aspect of civil society, then the legislature necessarily has to be much more precise and restraining and constraining the exercise of discretion. And moreover, there have to be safeguards to limit the potential for the governor to be arbitrary, to limit the possibility for favoritism.
So you answered part of my next question, but I'll let Mark and Ilya respond as well. What is the appropriate amount of emergency power that a governor should have?
Ilya, I'll defer to you to start.
The answer is it depends. It depends what kind of emergency it is. If there's a hurricane coming, then orders to evacuate the coast make some sense. With a pandemic, an order to evacuate the coast makes no sense. So you have that general police power, and again, as limited and restricted by state constitutional and statutory law. You have those sorts of things. But again, as we've been discussing, those authorities are checked not just by the state constitution and law, but by the federal Constitution if you're violating someone's First Amendment rights, Second Amendment rights, what have you, and by state civil rights protections as well. So you have both the power side, what is given to the governor, or delegated by the governor to health authorities or the relevant officials, and make sure all of those state law niceties are followed. And then you have people's rights assertions, both under state and federal constitutional law, that are also not absolute. So that's where the role of judges comes in, to make sure that whatever the state executive does, or the state government, even if the legislature legislates it, to make sure that it passes the smell test. Certain kinds of picking winners and losers, and you're essential, you're not. Aisle 3 of Walmart is okay. Aisle 6 gets shut down. That might not or shouldn't pass the smell test. But things like limiting the number of people per square foot of an indoor facility, or requiring whether masking or other types of whatever the prophylactic rules are that public health authorities that suggest can slow the spread, that sort of thing. Judges aren't supposed to be second guessing or making health policy, but they have to make sure that it's within the realm of things that make sense, and that a governor or a mayor isn't doing something that's just such an outlier that nobody else is doing, and what is their justification for doing it.
Mark, any?
Sure. So, I think to build upon Ilya's remarks, and we're having this discussion in the context of 9 months later. So much of what Ilya just set out is when you truly are in an emergency, and again, not to downplay the significance and seriousness of COVID-19, but the government has had a long time to start to figure out what does the science show us, what does the data show us works and doesn't work. So they may have powers in a vacuum, in a sense, when we don't know what will actually work or not work. When they restrict our liberties, what restrictions will actually advance the ball they're trying to advance. But when we talk about passing the smell test, if we're 9 months in and states that have had the most cumbersome and restrictive restrictions on liberty are seeing strong upticks, the largest, highest upticks in the country, and states that have tried to play it much more protective of liberty are seeing lower increases, or even no different increases in the way it's passing among the population than the nearby states, then you have to then really start to say, you adjust that smell test that Ilya mentioned. And then I'm going to distinguish between arbitrary, this aisle in Walmart is open and that aisle in Walmart is not open, which we definitely heard a lot of at the beginning of the pandemic. And just this concept in general of business shutdowns, that where is the data to show that shutting down businesses is improving how we respond to an emergency, if not, instead of actually exacerbating it. And so it was not unreasonable to ask by the end of April for evidence that these extreme, what in most instances would be considered clear violations of, say, the Fifth Amendment, your right to property, right to own your property and use it within the Supreme Court's restrictions on the Fifth Amendment. We can question those in a different webinar, but it's another when there's no evidence that these restrictions are addressing the emergency, and all they're doing is making life miserable for people. As I said, a good way to put it, perhaps a lot more succinctly than I did, was my boss, Governor Noem, said, I didn't define, she said, I didn't define what's an essential business and a non-essential business. That's not the role of government.
Thanks. And just as a reminder, please submit any questions that you have for the panelists at the bottom of the screen using the Q&A button. We'll get to those at the end. But I want to continue with this. Mark and Ilya, you both mentioned constitutional rights being infringed by these emergency orders. And Ilya, you mentioned that usually these things come under strict scrutiny. Courts closely look at these things to make sure that there's, is there a compelling government interest? Is it narrowly tailored? But at least at the beginning, it seemed like courts were going the other way and kind of punting and deferring to governors and mayors and their emergency orders. Are we starting to see first of all, is that appropriate for them to do when we're at the beginning of an emergency? And secondly, are we starting to see a shift? Are courts starting to look more deeply into these orders?
Yeah, I mean, at the beginning, it's definitely appropriate for courts to defer because they're no better judges than the, as it were, of the public policy, the best public policies. And in fact, it's not their role to exercise those police powers, their emergency powers, what have you. As things go on, I've said courts should be more skeptical. They've begun to be somewhat. They have begun to be when different kinds of establishments are treated differently for no real reason, whether that be churches or a gun store versus a toy store, these kinds of arbitrary distinctions, when in, part of this has to do with a change in the Supreme Court's personnel, frankly, because there's not much difference in treating churches that have large spaces and yet limiting them to lesser number of people than similarly large spaced businesses or casinos in Nevada or what have you. And we've seen a shift in that jurisprudence as Amy Coney Barrett joined the Supreme Court. But in general, I'm seeing more and more courts, and I think PLF, Luke, you might want to talk to this about the results in PLF's cases, because I think there is gradually more examination, and frankly, with the exception of kind of the Gavin Newsom extreme in California, most governors and executives are trying to be a little more parsimonious in terms of what kind of restrictions they put into place.
Luke, do you want to go ahead?
Yeah. Well, first of all, I absolutely think you're spot on in observing that the courts at the outset were very deferential. But when we brought our Ghost Golf case against Gavin Newsom, we were 7 months into ongoing emergency orders. And he made very clear when he released this blueprint regime, it was very complex. It very much looks like the sort of response that you would have expected to come from the legislature. It should have come from the legislature. But he made clear that he's going to continue to exercise his emergency powers indefinitely. There was, he gives each county a different color based on its assessed risk level, and with purple being the most extreme and yellow being the least extreme. But he said there's no green. And the reason for that was that we're not going back to normal anytime soon, is basically verbatim what he said. And so that made very clear that, for the foreseeable future, he's going to continue to do this. And the hope is in Ghost Golf, we're waiting right now on a decision on our preliminary injunction motion to block the governor's orders against the two businesses that we're representing there. And we're arguing on non-delegation grounds, as I set forth already. The governor just can't have a blank check to just do whatever he wants. He just can't make law. the hope is that the courts are going to realize, now that we're a year into the pandemic, now that we are 9 months into Governor Newsom's continuing rule, that they're going to have a problem with this. And I think we're beginning to see that with some recent decisions, even here in California. For example, the LA County the LA County Court gave a decision that caught a lot of attention recently, and saying that there wasn't evidence enough to support a municipal ordinance that prohibited outdoor dining on patios. And in fact, they really did fail to provide, point any serious evidence there. So it does show that the courts now are beginning to be more critical, and more willing to scrutinize. I think as a practical matter, as a judicial realist, the judges are more inclined to, at the outset, just give the benefit of the doubt. But one of the other factors, especially when it comes to these separation of powers issues, that I think is important, and that also counsels in favor of ruling in favor of our clients now, whereas maybe that wouldn't have been the case, say, in April, is the idea that, okay, maybe it was necessary for the governor to take some extreme actions in the very beginning. And I think a lot of people were willing to give some degree of benefit of the doubt in the beginning. But now that we're this far in, and as Mark has noted, the legislatures have had plenty of time to actually confer, to address this. I mean, the legislature here in California could enact, they're back in session, they could enact legislation adopting the blueprint regime that Governor Newsom has give us. They've had plenty of time to do that. And by the way, they've had plenty of time, when this was announced in the fall. Again, we were 6 months into the pandemic at that point, or into the emergency rule at that point. There would have been plenty of time for the governor to have allowed some degree of public input, all sorts. That's usually the way things are done. If the government is going to impose regulations that are going to restrict our freedom, typically they're expected to go through some sort of a process that actually allows for some opportunity for public comment. None of that was available. So there's no safeguards, either temporally, procedurally, or even substantively in California. So all in all, yeah, I think we're optimistic that we're going to begin to see the courts looking at this more seriously.
So you mentioned the legislatures being in session and trying to make changes. What can, well, you also mentioned earlier the powers that they've been given. What can state legislatures do to retake some of that power? We've put out a model policy that we've vetted with a bunch of different organizations and scholars. We're working with a few state legislatures on trying to push this through. But what are some of the things that state legislatures can do to take back some of that authority, to make sure that when they are in session, that they can actually do their job and legislate in these areas?
Well, for one, as you noted, there's a lot of states that have actually imposed time limits on how long the governor can exercise his emergency powers. So in the absence of that, that's a very obvious first thing to do. Now, some legislators might think that it's prudent to allow some degree of flexibility and to allow for emergency powers to go on longer than you or I might think. But there's got to be a way to put the genie back in the bottle. Otherwise you have the problem of the governor exercising unfettered power on an indefinite basis. So one obvious thing would be to provide a way to end the declaration, or to maybe allow for us having legislative oversight, to require some degree of legislative concurrence on especially things like business shutdowns, for example. North Carolina has an interesting provision in their Emergency Management Act that requires a concurrence from certain constitutional officers for certain enumerated emergency powers, which are deemed more controversial. And as I suggested a second ago, another thing that states could do if they really were contemplating allowing exercise of emergency powers on an ongoing basis, aside from narrowly enumerating what powers the governor can actually take, would be to, at the very least, provide for some degree of opportunity for public input.
Any thoughts, Mark or Ilya?
Mark, what powers do you want your ledge to take away from your boss?
Well, Ilya, it's been interesting because we're now getting into our legislative session. Next week, we start formally. And so we're in the time when legislators are starting to pre-file the bills that they plan to have presented in committee and ultimately voted upon. And so what we're seeing up here in South Dakota, sort of from a different perspective, but I think I'll then turn around and show how it would apply here, is we're looking at a governor who, when she entered executive orders over the last 9 months in response to the pandemic, most of the time those executive orders were loosening restrictions on the people. For example, reporting requirements that were hard to meet because of the pandemic, or meeting requirements that a commission or a nonprofit has to meet in person. So we relaxed them, and so we in fact gave more liberty to the people. What the governor did with her executive orders, Governor Nome, and so we're seeing the legislature come in now behind her and say, hey, these executive orders that allowed the people a little more room to live their lives worked, and there was really no downside. So maybe we should now introduce some bills that take these emergency orders that we put in place in response to the pandemic, and that for the most part we've now extended for another 6 months, because the pandemic obviously is not over yet, although we have our fingers crossed with the vaccines. We're seeing legislators try to introduce bills to sort of take what she did on an emergency rulemaking basis, or not even that, emergency administrative order basis, executive order basis, and put them into statute, which is a much better example of what the separation of powers is supposed to, how it's supposed to work. And so you would then ask those states where you see governors who are not doing what Governor Nome has been doing, which is allow the people more liberty, but rather because of the pandemic, so give them more space to figure out how to respond themselves as free Americans to the pandemic. But go to those states where they've been more restrictive, and the legislature should either say, we agree with that, and then of course the Constitution would of course always be a restriction on how far they could go, or we're going to rein the executive authority in. Of course, that's what I personally, speaking for myself, would rather see. But that's how I think the separation of powers is supposed to work. And I hope we see that as we're now entering legislative sessions all over the country for 2021.
The problem, as was mentioned earlier, I think Luke mentioned it, with what lawyers call non-delegation challenges, is a lot of legislators, especially when they are controlled by the same party as the governor, are perfectly happy to just give more power to the governor to avoid that political hit for any any decision they take in this tense area is going to be unpopular with some significant portion of their constituents. So this way they can just say, no, it's not me. We've given this discretionary power to the governor, and we'll let him or her take it away. That's what New York did. New York's legislature actually amended its emergency powers law in March to give Cuomo more powers.
Ilya, if I could just respond to that, because I mean, it's a very important point. A lot of these emergency management acts across the country do authorize the legislature to end the emergency declaration. Not all, and it's a real problem, for example, in North Carolina, where the legislature doesn't have the power to do that, and they've tried to exert themselves, and the governor has just vetoed them. But most of them do, and you're absolutely right that it's a problem, because generally speaking, there's not going to be enough political will to do anything. And it's also a tremendously blunt instrument. It means that if you're going to do that, then you have to get rid of everything, throw out the baby with the bathwater. If maybe there's some emergency orders that you're okay with, but others that you take issue with. And more importantly, I mean, stepping back for a moment to think about, I said a second ago that the California legislature could enact a law that does exactly the same thing as what Governor Newsom has done with this blueprint regime. That's true, but you have to remember that when the legislature does something like that, they have to actually listen to their constituents in a way that the governor in an ivory tower doesn't. And so there's a real problem here, say with Ghost Golf that we're representing, that they have no one to go complain to. I mean, they can go complain to their representatives all day long, but unless the courts intervene, they have no relief, because the rules just aren't coming from the legislature. And there's a reason the legislature is the lawmaking body. It's because it's the organ of government that's closest to the people.
All right. So I think that there are, talking about the different types of governors, I think we've seen a couple different types. We've seen governors who who have been light-handed, have, as Mark mentioned, have been trying to reduce regulation and red tape so that businesses can and individuals can thrive in these types of situations. There have been others who have been more heavy-handed in attempts to protect their constituents. And either way, I think that governors are resistant, obviously, to anyone taking their authority away. So is there a way to, what would you say to a legislature, and Mark, you don't have to answer this, but what would you say to a legislature where you have a governor who has been light-handed, and you actually trust the governor, you like that they have this authority, you trust that they won't abuse it, but the laws are still on the books that would allow somebody in the future to exercise these authorities that maybe go beyond what we would normally like to see vested in a single executive. And then on the flip side, if you're a state legislator in a state where you have a governor who has been more heavy-handed, and you don't like the way that they've been exercising their authority, and you want, even if the legislature is able to pass a reform, the governor is likely to veto it. I think we saw that in Michigan within the last few weeks. So what would you do if you were a state legislator in either of those situations?
Well, I think if I could take a first pass at it, at least, I think that this is where we then, when we talk about separation of powers, if the legislature simply wants to be restrictive, overly restrictive, then we're in a position, and which is what Ilya referred to, the idea that the New York legislature simply just rubber stamped or even helped Cuomo to be Governor Cuomo to be as restrictive as he was. It reminds me of the third branch, that we then have to be able to turn to the courts and expect the courts to do their job. The opposite of what Judge Oliver Wendell Holmes said when he said, if my fellow citizens want to go to hell, I will help them. That's my job. I think he said that in a letter to a friend. And that's really, I think, in 2021 in the United States, we do not think that's the proper role of the judiciary. The proper role of the judiciary is to guard the people's liberty. And so if you're a legislator who is in the minority, if you will, then you're going to want to go to the courts to ensure that these restrictions that are being put in place that appear to be unconstitutional, even in an emergency, even if there's some elasticity to liberty in an emergency, that it can't be overridden. And we have to expect the judges to step up and do their job. And I think we've seen that, whether it be as the expert on the Supreme Court on this call, Professor Ilya Shapiro, just be simply a matter of the nose count changed with Justice Coney Barrett joining the court, or that there was a recognition as time went on that the earlier decision that Chief Justice Roberts authored that went 5-4 the other way, which I think was California, but it could have been the Nevada case. Ilya, which one?
What's interesting about the later case, I think it was California. Nevada was a separate issue, and these were all emergency petitions for stays of orders. These were not argued before the court. Just to be clear for everyone, these were not cases that were fully briefed and argued. These are emergency petitions. But John Roberts, in the last case, in the Brooklyn diocese case, it was a Catholic diocese of Brooklyn and the largest synagogue in Brooklyn as well. And there, John Roberts concurred in the, pushing back on the New York order, saying that all you courts that have been citing my opinion or my one-page concurrence in that, what was it called, Cavalry Chapel case, the California case from earlier in the year, you've misconstrued it. You've oversold it, basically. So he himself, whether he was cutting back or whether he was just saying, look, that was May. This is this is December now, and things are different.
Any
So
other?
yeah, Daniel, that's pretty much what I would say, is we have to then turn to the third branch.
I'll say one other thing that we haven't hit on yet in this discussion, because we're all lawyers. There's a big non-legal, meaning cultural aspect to this. Just as people didn't need to have airports shut down to start flying, or restaurants closed to stop, eating at restaurants. I mean, there was huge drop-offs, before there were any official orders or lockdowns. And the airports, of course, never shut down at all. So at the end of the day, people, law, I mean, this is very philosophical, but law only works if there's sufficient buy-in towards its legitimacy. At a certain point, if a critical mass of people don't think that law is legitimate, it simply won't be obeyed, and it won't be enforced, because there's not enough cops on the street. First of all, they're not going to want to, they themselves will not think certain laws are legitimate, but also there's just not enough to go after the so-called Irish resistance. And by that, I mean not the violent troubles of Northern Ireland, but simply not going all along with laws that are seen as broadly illegitimate. And for that matter, people themselves will decide, even if there were no lockdowns, it's not like people would be flooding into restaurants. Some are deterred by certain restrictions, but mostly it's, we make judgments for our families and for ourselves. And do we have elderly or immunocompromised people that are in our family or what have you? All those sorts of things that go into this delicate dance. It's not simply, the governor decrees or the legislature does this or that, or judges are deferential enough or not enough. But there's the background cultural norms, and this is where respect for public health authorities and the damage that they've done to themselves over the past year in terms of no masks are no good, no masks are good now, or protests are not acceptable until protests are acceptable. These sorts of things really take away from the perception and the legitimacy and ultimately the legal culture backing up any kind of legal order.
Yeah, that's an interesting point, and I would note along those lines, I find it interesting that there's a number of sheriffs here in California who said, well, I'm not going to enforce these orders from the governor that people have to be wearing masks out of the street. Now, not all of them are saying that, but it does vary from locality to locality to what extent the local authorities are actually enforcing these issues, these orders from Governor Newsom. But getting back for a moment to Daniel's question about, what do you say to these legislators in states where the governor has actually exercised good some leniency and has had a soft hand. I mean that's true, for example, in Idaho, although I believe businesses were shut down in Idaho at one point, but he let off the pedal pretty quickly as compared to a number of governors across the country. And but Idaho is one of those states where the governor has, once an emergency is declared, all police powers of the state by statute. I think there's a constitutional problem with that. And, we could fight that battle, although the governor's been pretty good there as compared to other states. But the fact is, as more and more Californians, for example, flee this state to, in favor of, other places, the political winds can shift at any point. So I think that's relevant. If you're in one of these states, Daniel, you asked about where you're trying to enact legislation to reform, the Emergency Management Acts and the governor's emergency powers, and the governor is vetoing you. Well, obviously you're dealing with state constitutional rules there, but if the governor's vetoed you, well, the recourse at that point probably is to go to the poll, as they say, elections have consequences.
Great. Well, we have a lot of great questions from the queue, but real quickly, I want to ask one last question. We've seen emergencies declared on a bunch of things that you don't typically think of as emergencies. They are certainly serious issues that government can and should deal with, such as the opioid epidemic, homelessness, racism. Those kind of things have been declared emergencies by government. Do you think that what we're seeing now sets the precedent that governors can rule unilaterally in these areas just by declaring them an emergency?
Well, it certainly is a disconcerting proposition that the governor could, but I think under the rationale here in California, an emergency, by the way, is defined as any condition that threatens health and human property, health, safety. And so, by that logic, the governor could, and we've seen as, emergency declaration over opioids and certainly, climate change might be on the table, right? But if the governor of some state was to declare an emergency and say, we're going to require, cap and trade under my emergency declaration, especially on an ongoing basis, to combat climate change, I think there would be a real problem with that. Where it looks like the governor is using emergency powers for expedient means of accomplishing ideological goals on controversial matters that really have traditionally been subject of debate in the legislature, I think they're going to be in especially hot water.
It also depends what you're doing pursuant to the emergency declaration. I mean, in a certain sense, if you're just Michael Scott in the office saying, I declare emergency, well, okay, and what, right? Because if you're declaring emergency because of opioids, and then pursuant to that, you're locking down restaurants, that makes no sense, right? So pandemics don't come along, thank God, and hopefully in the future very often, right? The last time we had one this big was 100 years ago, the flu in 1918. So it again depends what is being done at the behest of these emergency powers, and that you see federal corollaries as well. I mean, we are currently living under, ongoing 30 emergencies are still ongoing at the federal level, including one that was declared over election fraud in the 2006 Belarusian presidential election, right? But it's not like President Bush or after him Obama or now Trump have done certain things in the United States responding to this Belarusian ongoing emergency, right? So it just, where the rubber hits the road is where it has to be evaluated.
All right, I'm going to go ahead and move us to our audience Q&A. We've got a lot of great questions. I'm going to combine a few of them because I think a lot of them are in the same vein. So, for example, what limits are there on the ability of government to implement eviction moratoriums, to limit gatherings, to close down indoor dining? What authority do governors and government generally have to do such things?
This goes back to the basic police power, the idea that we all have our individual liberty, but my liberty to swing my fist around ends at the point of your nose. And the issue with the pandemic is we are all potentially fist swingers. We don't know, unless there's like an instant test or something that's developed with immunity bracelets that's verifiable quickly or something like that. We don't know who's not a fist swinger. And so especially this gets back to the top of this discussion. When we, things are in a flux, we don't know much about the epidemiology, et cetera. That's where the power to regulate and restrict for this crisis situation comes from. But again, as we've been discussing, there's a difference between shutting down indoor rock concerts and sporting events versus private outdoor family gatherings or something, and everything in between. So it's not a clear, hard and fast rule.
And I would connect what Ilya just said with something he said earlier, which is, yes, it's their police powers, but then how far does the government go? Yes, the state government has police powers, but if it goes too far, it's not going to be enforceable. We're going to see law enforcement officers saying we refuse to enforce the law, as we've seen in California and I think elsewhere. But you're also going to see people become contemptuous of the law. So one of the questions I saw said, can the state government limit people inside their private home? Well, that's virtually unenforceable. And so it then, and also secondarily, probably easily worked around. And so you're sending a message to the people that the law is not going to be enforced. And so the law is really just a declaration that has no enforcement mechanism and it will not be enforced. It sort of makes the people contemptuous of the law. Why should I follow that? There's really no way I can be punished. Or I see other people getting away with doing things. Why should I? And that kind of gets at a point I made very much at the beginning about norms, that when our leaders don't follow the norms that we've developed over 200 plus years, whether it be in an election or in a pandemic, it sends a message to the people that the rules don't really apply. and we can just pick and choose what we want to follow. And it can really cause a problem for society and for what is the greatest country the world has ever seen. And so our leaders need to be careful to recognize there are restrictions on their authority, and they can't be going so far with their police powers that no one takes them seriously.
Yeah, all of that is true. I would say, undoubtedly, again, the state does have power to, police power to protect public health and safety, sure. But again, the separation of powers doctrine asks who exercises that power. So, for a lot of this, again, I think the answer is the legislature should be making the rules, not the governor. But if you assume for the moment that the governor has been validly delegated authority to do whatever we're talking about here, then we still do have, the Bill of Rights, for example. And we're challenging, someone asked about the eviction moratoriums. We're challenging Washington and Seattle's ordinance and statute imposing a moratorium on evictions because we think that that violates the takings clause and it violates the contracts clause. And so, when you talk about, restricting people's, personal liberty to gather with their family for, a wedding, there's freedom of association issues there, the First Amendment implications. So, we have to look at these things on a case-by-case basis.
Does anybody want to hit specifically on the eviction moratoriums? I know that is a huge and hot issue right now.
I'll just say quickly that there was something on eviction moratoriums in a presidential executive order, and that is problematic. I think the federal government has no role in regulating local real estate and regulation of housing and so forth. At the local level, it depends. So the analysis of property rights depends on whether a regulation is how much of the value of property it's destroying, whether it's temporary or permanent. Is there any just compensation being offered? Is it targeted, precisely, all these different things. If it gets long enough, eviction moratoria, then you're basically rewriting the whole housing code, and that becomes a taking at a certain point. If it's a temporary thing, then that's another matter. But I think there was something in the news this week. I forget which state or city this was in, but a landlord himself was being evicted because he couldn't pay his mortgage because his tenants weren't paying their rent and he couldn't evict them.
Ilya, by the way, we have 2 lawsuits right now against CDC for a national moratorium that they enacted pursuant to that executive order from President Trump. And
let me know when I can file an amicus brief.
We're going up on appeal to the 5th Circuit. So I'll let you know.
So Luke, I think this question is a good one for you to answer. Is PLF working on any cases regarding Washington State and Governor Inslee's restrictions and emergency orders?
I've had a few small business owners reach out to me in Washington State. In fact, I am taking a very close look at Washington right now. As I mentioned, that's one of the states where the governor has been given basically a blank check. The statute doesn't quite say all police powers of the state the way California does, but it basically says he can do anything he thinks is appropriate and necessary in responding to an emergency. And Washington has a non-delegation doctrine, much like these other states we've talked about. So we're exploring that, and stay tuned.
So I like this next question. It's how is it that some state governments consider public input as their holy grail, now have suspended such input in meeting? I think they mean, you can't have access to state houses or other things. I'm dealing with that issue right now, trying to figure out where we can meet with legislators. Is what kind of problems does that raise? Luke, you mentioned that, I think it was you, Luke, who mentioned that state legislatures are places where people typically have access to someone with some amount of power, much easier than the governor's office. So, I mean, are there any workarounds? What is this a big issue that we're seeing? Mark, did you want to say something?
Well, I was just going to say, I mean, the workaround is to not be overly restrictive in the first place. You just immediately reminded me, Daniel, of here in South Dakota, where we've been much, much less restrictive at all, really. We basically allow the people to live their lives like normal. If you go into a business that has a mask mandate, that business has it, so you wear it. Here in the Capitol, people walk around. Some people have masks on, some don't. But if you want to meet with a legislator, you call them up and you can meet with them. And that's your choice as an American, whether you're willing to go meet with that person. Where I'm sitting here today in my office at the Capitol, just as almost my entire team is. People who've had brushes with somebody who has COVID, of course, work from home for a few weeks. So we take reasonable measures consistent with what the CDC says, but we don't mandate it. And so then you don't need a workaround. You rather simply live the way we always live, which is we measure risk. We expect Americans to measure all sorts of risks, whether it is when they drive on the highway from New York to DC versus get on an airplane versus get on the train. Those are different risks. And this is just another risk that we have to expect Americans to figure out for themselves. And each person's going to figure it out differently. Each person's going to balance the risk. But that's the way, that's to me, I would say the American way to work around the problem.
All right, well, we are about out of time. So any final words of any points that you wanted to make that you weren't able to during our discussion? Mark, you look
Not
like
from South Dakota. Not from South Dakota.
Billy or Luke?
Vote with your feet. You know, I'm just looking through the Q&A. There's people from Washington, from California, you know, despair that the legislature would just back up the governor. Well, you know, vote with your feet.
Yeah, no, that's I'm trying to convince my wife to move to a more free state. So but yeah, be that as it may, not all of us have the ability to pick up and go immediately. So it is important that we continue to fight for our constitutional liberties, to protect the structural protections intended to preserve our liberties wherever we are. And so the Pacific Legal Foundation, we're going to continue to fight these fights, even when it's an uphill battle, like in California.
All right. Well, with that, I want to thank our panelists for joining us, and I'll just remind you again that we have a lot of information about this issue in the chat. I'll plug one more time. We have a set of principles that we've put out for legislative reforms that would put safeguards on emergency orders that we're really excited about. Thank you again for participating. I hope that you will continue to join us for this series. These Battleground America series is happening every Friday for the month of January. And thanks again. Appreciate it.
Thank you, Daniel. Thank you, Pacific Legal Foundation.